Here we go again, another day in court, and someone definitely underestimated how long things would take. Rookie move. When a judge says I scheduled the whole day, you know this isn't their first courtroom rodeo.
Olsiums et al., formerly doing business as Keeson's Enterprises LLC, Castle Advocacy Group Inc., Professional Services Corporation. And we also have Susan Olsiums present as well. We're here today on the partial remand with regards to the attorney's fees on this case. We have been waiting a significant amount of time on this appeal. The matter went up to the Court of Appeals and the court was affirmed, but it was sent back to the court as it relates to the attorney's fees. The Court of Appeals did state that as to the attorney's fees and the way that the court assessed the fees was appropriate, but in the amount of the fees and the fact that this is a case that went into significant litigation and had a substantial amount of attorney's fees, that there needs to be more information provided to the court in order to go over 3 times the award of damages to the plaintiffs. Therefore, the court does need more information from the plaintiffs and from counsel in order to proceed, unless the court is to rely on the statute, Wisconsin Statute 814.04 paren 2 paren A, where there would be the idea that it would only be 3 times the compensatory damages that the plaintiffs received. I'm going to first ask for arguments from both sides, and then, or if it is requested, to go into depth as to the specific factors. Mr. Anderson.
Thank you, Your Honor. I wasn't entirely sure what the hearing was going to be about today. I mean, I knew the topic, obviously, given the Court of Appeals decision, but I wasn't certain what the court would be looking for. We can go into the list of factors, although that may be broader than what we're prepared to all do here today in terms of if the court wants additional evidence or things like that. So I don't know if it's the right thing to go into that in detail. Generally speaking, though, Your Honor, in my September 27th, 2022 submission to the court, it was a lot of it is covered in that document. I'm not going to go through all of that again, but the court is well aware of this case.
Legal twist alert. The Court of Appeals basically said, your math isn't mathing. Even though the fee structure was technically fine, the amount raised eyebrows. Judges can't just rubber stamp massive legal bills. There has to be backup. Otherwise, it's 3 times the damages and no more.
The fees in this case were reasonable given the time spent, and I know that's the time spent and the hourly rate that was charged. But what I think that the Court of Appeals may have missed in this one, Judge, is the fact that this was, I think, 3 hearings in front of Commissioner Krupa, a full day in front of Your Honor, motions filed by defendants that were summarily denied and dismissed, and ultimately, Your Honor, up on appeal to the Court of Appeals. Now, I will also say that the attorney's fees that have been awarded thus far in this case do not even include the attorney's fees to deal with the appeal filed by defendants. And I think that should be taken into consideration as well when considering the award of attorney's fees in this case. Your Honor, this case was, in my humble opinion, simply over litigated by defense. And what I mean by that is, again, I just sort of said it, 3 hearings in front of Commissioner Krupa, motions filed, a full day hearing, and really, Judge, the motions didn't really have any merit. I understand that the defense is pro se, but that costs attorney's fees to plaintiff when they have hired an attorney to deal with the motions that did not have any merit. Your Honor, the cross-examination in this case.
I'm going to stop you right there. I know all of that.
Okay.
That was in my decision that went up to the Court of Appeals. And unless you're going to appeal to the Supreme Court, I can't overrule the Court of Appeals. And I will need the specific factors as they are directing me to go over the 3 times of the compensatory damages that were awarded to the plaintiff. Otherwise, I'm stuck with the 3 times the compensatory damages. The factors in Wisconsin statute 814.045, and I used your letter brief when I did my decision because honestly, that's what I had. And I put in the information that this was, in your words, over litigated, and we had those multiple things. However, that did not appease the Court of Appeals. Therefore, we need more. They need more oomph.
Okay.
Otherwise, again, we're stuck with that other statute, which just says the 3 times.
Then I would suggest and ask that a written submission be allowed to this court. I can have it done in 21 days.
All right, Mr. Olsiams.
3 times the statute says 3 times compensatory.
Well, it doesn't say that that's what it's limited to.
And here's the courtroom tea. Anderson's dropping a subtle burn saying the defense buried this case in pointless motions just to wear everyone down. That strategy? Expensive. And the court is clearly not amused.
Is that your argument?
Yeah.
Okay. All right. Well, so I will allow each party to present their arguments based upon the Wisconsin statute 814.045, which does have those specific factors identified, and then look specifically at Wisconsin statute 814.045 paren 2A, which does go into where it states, in any action in which compensatory damages are awarded, the court shall presume that reasonable attorney's fees do not exceed 3 times the amount of the compensatory damages awarded by this presumption. But this presumption may be overcome if the court determines, after considering the factors set forth in subdivision 1, that a greater amount is reasonable. So unless the court can find that it is beyond, it is reasonable to go above the 3 times, then we would be limited to the 3 times the amount of the compensatory damages. I believe that the Court of Appeals decision is quite clear. Quite honestly, I thought I followed that, but the Court of Appeals wanted more, and that's fine. We do what we're told. So I will give 2 weeks for each of you to provide. How about 3 weeks? Is 3 weeks enough?
That makes it, with Memorial Day in there, it helps to have the extra week. So June 3rd-ish.
June 3rd?
That's fine by plaintiff.
Does that work, Mr. Olsiams?
Yes, Your Honor.
June 3rd? And it shouldn't be very lengthy. We're just going over the factors and whether or not the court should follow that presumption of 3 times compensatory damages. All right.
Your Honor?
Yes,
Sorry. May I say something?
you may.
So I am unaware of all this.
You were not a part of this. You may,
Yeah, I think she was dismissed.
out of the first action, I believe you were dismissed out of the
Was I
first
a
action.
part of the appeal?
I don't believe you were.
No.
No.
So I think you don't have to worry about that, that matter. You were just involved in the first part, but then you were later dismissed. And then now we're going to go on to the second case in which you are at this time a party. All right, we are adjourned on as to that matter. We will go on the record as to 23 CV 86. Rick Brimacombe et al. Versus Carl Olsiams et al. Appearances are, we have appearing in person, Christopher Anderson, counsel for Mr. Brimacombe. We have Carl Olsiams appearing without counsel, and we have Suzanne Olsiams appearing without counsel. We're set today in this matter for a follow-up hearing to attain additional information for the court to be able to provide its final decision as it relates to this matter. We were set for a motion hearing and a contempt hearing, a damages hearing, and then a contempt hearing as it relates to the underlying issues. It was heard on February 4th, 2025. As the court was going through and trying to prepare its decision, there was some information that was still needed in order to finish or to continue with a full decision in this case. Therefore, I am going to ask the parties if they have any additional information as it relates to the damages. Because I believe that was a little bit lacking. I did get more information in the argument portion from the attorneys. I got some in testimony, but quite honestly, the arguments of both parties, even though I understand Mr. Olsiums is a party / representing himself, that makes it a little bit more gray, because a lot of the arguments or information came from Mr. Anderson with regards to the damages. So I just want the parties to be able to either provide a little bit more information as to the damages and or provide counter information to the damages, just so I have a better understanding. So if there are any, if anyone wants to proceed, this was your hearing or your motion, Mr. Anderson and Mr. Brimacombe.
Your Honor, are you looking for anything specific? I wasn't sure, coming up here today, I wasn't sure what the court was looking for the hearing itself. And so we have Mr. Brimacombe here. If testimony is needed, I wasn't prepared for a testimonial or evidentiary hearing, Your Honor. I wasn't sure what the court was looking for.
As to kind of like bullet pointing, you're asking for damages for A, for B, for C,
Okay.
and then the dollar amounts for A, for B, for C, and then what are they? Because it was kind of difficult the
Okay,
way the hearing went
yeah,
the last time to be able to have testimony and then counter testimony, to be able to put that all together and formulate that into a decision. I could use the arguments,
Can I jump in?
but the arguments are from the attorney / party / attorney. Mr. Olsiums?
Simply, there were no proven damages. They produced no receipts. They just conjecture, guessing. I think I laid that out pretty well in my arguments, that they presented no evidence of any damages. They claim.
Well, Mr. Olsiums, and here's so you can understand, the law says that they don't have to have receipts. They don't have to have those things. It can come from their own personal information and their idea. That he could say, anyone could say, yes, I purchased this for $59.
Well, they didn't even prove that there was any damage. Not only did they prove no damage, they didn't show any type of a compensatory or any type of
And again,
evidence.
Mr. Olsiums, that's for me to decide. And I have made certain decisions, and I have heard that there have been dollar amounts stated for certain things. And
Notice how the judge wants things in bullet points now. That's a courtroom clue. When testimony turns into chaos, judges hit pause and demand structure. It's like saying, bring receipts or sit down.
testimony and your opposition that there was not any damage. And again, but most of the dollars, I've heard the damages that were being identified, and I heard dollar amounts, but for the most part, the summary of the damages came from the argument of counsel and the opposition in your opposition, Mr. Olsiums. And that's why I just wanted to make sure that I heard correctly, unless if there is or there is not.
yeah, and I can provide the list if you want. I can do it verbally right now, or I can provide it in writing, whatever the court prefers. But I think I can separate it out for the contempt piece, and then I can separate or from the nuisance part and the loss of enjoyment of property and the violations of the law, if you will, for renting the property and running a business on property that they shouldn't have been doing that on.
And that's where I think it got a little bit confusing and a little bit out of order. I'm trying to say this very tactfully.
Say it.
Because it was not a very organized and controlled hearing. And so that's why I need it to be a little bit more organized and controlled. And I like that you have that, Mr. Anderson, but I would need a party to testify to that and that we can have it as an exhibit, but then we can have Mr. Olsium's contest that and he can provide his opposition to that. But I just need to make sure that I have it all separated, what is being asked for as the contempt versus what is being asked for as the damages portion.
As far as the contempt, Your Honor, Mr. Olsium, or I'm sorry, Mr. Brimacombe can't testify to that. Ms. Haskins and Ms.
I have that.
Rotman, they testified. So the damages that we're asking for there are simply the amount of money that was paid by them to the Olsiums.
And I have that.
Okay.
Then we're good with that part.
We're good with that. And then attorney's fees for that, and I have that at $2,970, Your Honor. I can provide additional detail, which I have not yet done. Wasn't sure what the court was going to do with
And
that.
then that's where you're gonna have to come in and give me a specific statute that would allow me to provide you with those attorney's fees. Because I'm gonna follow the Court of Appeals decision and I'm not going to, unless you have a statute for me that would allow it, as they state, you each their own, carry your own attorney's fees, unless you have a specific statute that would direct me otherwise.
I will get that to you, Your Honor, because it's a contempt. I think the court has the authority to do that, but I will get you the specific statute. I don't have it off the top of my head right now.
Okay. Because I don't want to run into the same issue with the Court of Appeals.
Understood. Understood. So that's on the contempt. You need anything more on that?
No, I do not.
Okay. Then on the nuisance damages, Your Honor, I mean, I can have Mr. Brimacombe go back up, but he testified to the
Let me get
out of
to my
pockets.
notes. I have very,
Okay.
as good of notes that I could with the way the hearing went.
Mhm.
So I can go directly to where Mr. Brimacombe testified. Yeah, I'm here. I have his notes right here.
Okay.
So you can present an argument if you wish right now.
Yes, Your Honor. And so to start, there was a survey of $2,000. There was we'll call it a repair of the survey because of the removal of the stakes by the Olsiums. And that repair was $600. And that was testified to by Mr. Brimacombe at the hearing. Frankly, Your Honor, there's a third time that was not yet testified to because it happened the day of the last hearing on February 4th. And the stake was removed again after the hearing by the Olsiums. That is going to have to be fixed again. Your Honor, there are cameras that Mr. Brimacombe testified to. The cost of that, he testified, was $150 per camera. And there were 9 cameras. Your Honor, that amounted to $1,350. And then there was a repair of the camera that was damaged of $150 additional. Lastly, Mr. Brimacombe testified about the monitoring of the cameras being $2,160. The total for those expenses, Your Honor, as I have it now without the repair or having the surveyor come back out for a third time, was $6,260. Those are the hard costs.
All right. Now let me just double check. I want to make sure that I have my notes.
Can I respond?
You will as when I'm ready. See, I only have 8 in my notes as the cameras that were damaged.
Well, there was.
That's all I have.
There
in
was
my
only
notes.
one camera that was damaged.
Well, I have,
I just want to make sure we're speaking the same
well,
language.
I have trail cameras damaged. There were 3, but 1 was beyond repair. 3 that were close to the property and 1 at the end of the driveway.
And only the one was the one that required cost, Your Honor, to fix.
So there was only one that was really
Or,
damaged.
yeah, one that had to be replaced. It was damaged beyond repair, I should say.
All right, Mr. Olsiums.
None of those are a survey is not a damage. Repairing a survey marker doesn't cost $600 and is not damage. $13.50 for cameras. There was only one camera that they testified that was damaged, and again, there was no proof that I damaged any camera, Suzanne damaged any camera. Monitoring of cameras, that's not damage either. Again, Your Honor, I just want to point out that this is not a real case. There's no damages. What they're basically trying to do is to get us to stop renting our property. They didn't provide any evidence of any damages, much less that I damaged anything or Suzanne damaged anything. These are pie in the sky, not damages. They're just numbers. Survey is not damage. Repairing a stake is not damage. And there's no
Classic defense play. Deny, deny, deny. Olsiums argues that nothing counts as real damage. But here's the legal kicker: perception of loss can count, and the law doesn't always demand a paper trail. This one's a battle of credibility.
evidence that I damaged the stake. There's no evidence of anything here. It's just all conjecture. There are no damages. Again, I would ask that their claims be dismissed because there are no damages here. Surveys aren't damages. Putting a stake back in the ground, it takes somebody to take a hammer and pound it back in. And again, there's no contempt. The county ordinance says 10 days or less.
We don't need to get into the contempt.
Okay.
Not there. All right, thank you, Miss. Miss.
Olsiams.
Olsiums. I can't remember what your maiden name was. I'm sorry.
Beskar. Yeah.
Beskar. Miss Olsiums, do you have anything to say?
Other than I, as testified, was not involved, my name.
You don't have to say anything. You can say just you're relying on what you stated the last hearing.
nothing
All right.
From that. Thank you.
Unless anyone wants to provide any additional sworn testimony, I think I have it. I just needed to make sure that I had what was stated at the last hearing and compare it to my notes to make sure that I had what was being asked for, because there were other things that were testified to that could have been damages, but they were not being asked for in a monetary amount, such as no trespass signs, and then the damage to that easement road, those types of things. But then there were non-monetary, I guess. There was no dollar amounts requested. So I just wanted to make sure that I was on the same page and that.
So, Your Honor, may I respond to what, maybe I don't need to respond to the specifics of what Mr. Olsiams just said, but obviously we believe that they are damages. You have to get a survey to keep people off your property.
Correct.
Okay,
Yes.
I don't, you understand our side on that?
I understand both
Okay.
sides.
The last piece, though, Your Honor, that I did not address, I was trying to take them in pieces, the hard cost, but then also the fact that my clients have lost the ability to enjoy their property while there are 15 vehicles and 18 people running around.
Yeah, I understand that stuff. I just needed
Alright.
to understand if nobody's seeking any monetary amount for any of the alleged timber trees that were cut, that damage to that big tree that was talked about, the no trespassing signs, the damage to the easement road.
That's because there were no damages.
I'm not talking to you. But, and the fact that there were perhaps discarded waste allegations, but for those alleged actions and alleged damages, there's no monetary amount sought. Is that correct?
It is correct with respect to a specific dollar amount, but all of that goes to my client's inability to enjoy their property to a certain extent. And those numbers are in our submission to the court from our closing argument and go to basically my clients having to be the caretakers up there when the Alciums are 100 miles away, which I put in my brief is also a violation of Burnett County ordinance. And so all of that, Your Honor, goes to my clients basically working when they're up there at times, dealing with renters who are asking them questions, who are getting stranded on the lake, et cetera. And so all of that, again, goes to the $630,000 of ill-gotten gains that the Alciums received because they were running a business when they shouldn't have and where they shouldn't have. So there aren't specific dollar amounts that go with those, Your Honor, but it's all part of the overall claim that is my client's inability to enjoy their property and have this serene, tranquil experience that they expected when they went up there.
Okay, Mr. Alciums?
And again, that's nonsense. It's only a few weeks every summer. There are no damages. Again, they're just reaching. They're just basically trying to get us to stop renting our property. Not enjoying your property. Again, he was able to go to the property. He's able to get to his property. There weren't 15, again, the evidence shows there weren't 15 cars parked there. So again, this is all a reach. There are no damages. There's no contempt. And I've been in compliance with the 10-day order from last year and this year as well.
Okay, thank you. Now, the only other thing that I'm going to need then to wrap this all up is the argument for attorney's fees. And if you believe that attorney's fees should be granted, and if you believe that they should not be granted. Mr. Anderson is going to argue that they should be granted, and he's going to find a statute that says that there's authority to do so. And would you like to have Mr. Anderson file first and you do a response, or would you like it to be a dual filing, Mr. Alciums?
He can file first.
Okay. So, Mr. Anderson, do you believe that you can have both of your filings by the 3rd, or do you need additional time?
Third's fine.
All right, so have both of your filings by the 3rd. And Mr. Alciums, your 21 SC case will be due the 3rd, but your attorney's fees matter will be due on June 10th. Is that okay? Or would you need another, or would you need till June 16th or 17th?
June 17th.
All right, so June 17th, your response can be due, okay? So then that would be the last thing to wrap all of this up, and then I will have everything I need to complete my decision. Okay? All right, thank you.
Your Honor.
And there it is, deadlines locked, filings due, and the courtroom chess match continues. Will attorney's fees be granted? Will the damages stick? Don't blink, this judge is meticulous, and we're one good statute citation away from a major ruling.